Welcome back to the Deep Dive. Today we are really strapping in for a forensic look at some advanced legal maneuvering.
Yeah, the kind of stuff often called lawfare, high-stakes procedural warfare.
Exactly. Our mission is to kind of dissect this complex series of steps taken by opposing counsel Morgan Hibner and also a new attorney who's popped up, Troy G. Pickett.
And the point seems to be not winning on the merits, right? But rather obstructing justice, maybe concealing key facts from the court.
That's the core of it, yeah.
Yeah.
We've got a stack of sources detailing these alleged attempts at, well, procedural fraud in the state courts.
And it's all playing out against the backdrop of a new, pretty significant federal civil rights lawsuit.
What's striking is the apparent intentionality, the mislabeling of court documents, the calculated timing. It really provides a case study in how the legal system might be weaponized.
It really does. And we're looking for the pattern here, right?
Mm-hmm.
The legal vaccine pipeline, which, traps these kinds of systemic issues, identified this whole sequence.
Identified it as what, exactly?
As a tactic designed to protect specific, let's say, high-value targets within this alleged network. We're going to try and reveal how that concealment mechanism worked, step by step.
Okay, so the legal vaccine isn't just looking at what happened, but the why.
Precisely. It compares these moves against, thousands of known network tactics. And the analysis here, well, it suggests the whole operation was structured, a deliberate attempt to create a legal shield.
A shield to stop the plaintiff's core allegations from ever being reviewed by a judge who might actually feel compelled to act on them.
That's the theory laid out in the sources, yeah. Preventing that substantive review.
Okay, let's start on the ground then, back in the state courthouse, because things really kicked off after that contentious hearing on October 10th, 2025, in the 387th Court. Can you walk us through that initial scene?
Yeah, October 10th. Judge Lawfare was very clear. The temporary orders draft, the main issue, was, quote, heavily contested. In open court, the judge told both sides, come back, meet in person, October 16th, signaling pretty clearly these orders were not final. They hadn't been signed. That context is crucial.
Okay, so the judge says basically, we'll sort this out next week. But what did Morgan Hibner, the opposing counsel, do almost immediately after, within hours?
She filed Index 81, and the title of this document, well, that's the first layer of this alleged deception.
What was it called?
She labeled it Notice of Entry Temporary Orders. Now think about that. To a court clerk, to the public, or critically, to an appellate court just looking at the docket online.
It looks like the orders were done. Signed, sealed, delivered on October 10th. Finality.
Exactly. It signals finality. But if you actually read the document itself, not just the title.
The content tells a different story.
Completely different. You peel back that label, look at the fine print, and it was not an entry of orders at all. It was just a notice for a future hearing.
The hearing the judge had already scheduled.
Yes. It explicitly stated that notice of entry will be considered on October 16th, the date the judge had already set for them to come back and hash out the contested draft.
So the title was just wrong. A misrepresentation.
The sources call it a deliberate ruse designed specifically to create a false impression of finality on the public record.
And this misleading title had an immediate and pretty devastating procedural effect, right? Because the plaintiff had already filed something with the appellate court.
That's right. The plaintiff had filed a petition for writ of mandamus, basically asking the appellate court, hey, can you compel the trial judge to actually sign these orders so we can appeal them?
And this is where MH's filing Index 81 comes in.
This is where the trap snapped shut. The First Appellate Court of Texas looks at the public docket. They see MH's filing titled Notice of Entry.
And they assume?
They assume the orders were signed on October 10th, just like the title says. So they denied the plaintiff's petition for writ of mandamus, ruled it was a moot point.
Moot, meaning pointless.
Yeah, why force a judge to do something that, according to the official record, they've already done?
Okay, let's pause on that phrase, moot point. What does that actually mean procedurally for the plaintiff, for the substance of their case?
Oh, it's huge. It's the difference between having your arguments heard and just being completely ignored.
So the appellate court didn't look at the merits at all, the facts, the argument?
No, not at all. They didn't look at the substance of the petition, which laid out all the underlying issues. They dismissed it purely on a technicality.
A technicality created by MH's allegedly deceptive filing.
Exactly. It basically rendered the plaintiff's whole effort to compel accountability and, maybe more importantly, the exposure of sensitive information in that petition completely null and void, locked the door.
And the timing here, The sources highlight this, too. That dismissal came down just, 8 hours after the plaintiff filed an emergency TRO.
Yeah, an urgent temporary restraining order, alleging imminent danger to the child, things like unsafe vehicle conditions, really serious stuff.
So the moot point ruling didn't just kill the mandamus petition.
It effectively killed the emergency motion for child safety, too, without ever looking at the substance of those safety concerns. The procedural fraud, as the sources describe it, successfully blocked the appellate court from reviewing any part of the case on its merits, including the immediate safety claims.
Okay, so the alleged fraud worked in the short term, silenced the appeal, buried the evidence, but the sources suggest MH might have slipped up in the next hearing. Kind of confirmed her role. Tell us about October 16th.
Right, October 16th. The day the judge originally set for them to meet. They get there, and the plaintiff files a second motion to recuse the judge.
Why recuse?
Citing this pattern of due process violations, including this judicial bait and switch, the appearance that orders were signed on the 10th, even though everyone knew they were meeting on the 16th to discuss them.
Okay. And how did Morgan Hibner react?
Instead of just letting it happen or staying quiet, she immediately jumped up to oppose the motion. And what she said was, well, pretty explosive, according to the record.
What would she say?
She claimed the motion was, quote, based on something that did not happen.
Wait, did not happen. But she filed a document that made it look like it happened.
Exactly. Think about that contradiction. MH is the one who filed Index 81, the notice of entry, which caused the appellate court to believe the orders were signed on the 10th.
Yet now she's in the trial court on the 16th, arguing the whole basis for the recusal, the idea the orders were signed, did not happen.
Well, it looks like she's confirming that the document she filed just days before was specifically meant to mislead the appellate court.
Because if the orders hadn't been signed, as she now claims,
then why title her filing Notice of Entry? Why let the docket misrepresent the judicial record?
it suggests she knew all along the judge hadn't signed them.
It points strongly towards prior knowledge, yes. It looks like the smoking gun regarding her intent, as the sources frame it. She knew the judge hadn't signed, which allowed her to say the recusal premise did not happen, but she relied on the false docket entry that she created to get the appeal dismissed.
Wow, that's quite an alleged error. The sources say it exposes her direct involvement in this alleged fraud against two courts at the same time.
That's the argument presented, yes. And there's another interesting point the sources raise about that moment.
What's that?
Logically, if you're an attorney who just scored a procedural win for your client getting these delayed, unappealable orders, you might actually welcome a recusal motion. Why?
Because it causes more delay.
Yeah.
Buys more time.
Exactly. More delay generally favors the side that won the temporary orders. But instead, MH fought the recusal tooth and nail.
Which suggests?
It suggests, according to the analysis, that her primary loyalty might not have been to her client's specific win in that moment, but maybe to the network's larger goal.
Which was?
Protecting the procedural chaos itself. Protecting the process of obfuscation, which could then be used to discredit the plaintiff more broadly, especially with a federal case looming. She was defending the tactic, not necessarily the client's immediate interest in delay.
Okay, that brings us to the why. Why go through all this? The alleged deception, the risk, just to get a case dismissed as moot.
Because of what was in the document that got dismissed, this is really the core of the legal vaccine pipeline's inference here.
Okay.
The procedural dismissal wasn't just about stopping the appeal. It was essential, the theory goes, to prevent any judge from actually reading the contents of that petition for writ of mandamus.
And what was in that petition that was apparently so sensitive, so radioactive, that it required this kind of high-speed procedural strike to bury it?
The petition included a transcript, court testimony documents that explicitly named names.
Names of who?
High-profile individual, entities connected to the alleged criminal network and the underlying conspiracy the plaintiff has been detailing.
And plaintiff's strategy was?
The strategy, confirmed by the sources, was pretty clear. Put these names, in black and white, in a court filing detailing systemic lawfare, right in front of an appellate court. The hope, or perhaps expectation, was that seeing these specific names would compel a judge to say, whoa, I need to refer this to the FBI.
Okay, let's talk specifics then. Who are we talking about? Which names and entities were allegedly being shielded here?
We're talking about some pretty significant figures, people who've held positions of power. The transcript references included Robert Mueller.
The former FBI director.
Yes. Also, Philip E. Denning, an individual linked to alleged local harassment incidents against the plaintiff. Damon Sachs, the law firm Roberts, Markle, Weinberg, Butler, Haley, PC.
Weren't they involved in some suspicious HOA actions related to the plaintiff?
That's the connection alleged in the sources, yes. Pages 107 and 116 of the transcript apparently reference them. Also, names like Kevin Eckhart and Mark Swisher appear. These aren't small players.
No. And having them named in an official appellate court filing tied to allegations of conspiracy and lawfare, that would be a major risk for them.
Clearly deemed an unacceptable risk, it seems. So the minute those names hit the appellate court docket, which was October 6th when the petition was filed,
the clock started ticking for the network to shut it down.
That's exactly what the timeline suggests. Petition filed, names exposed on the 6th. 4 days later, October 10th, boom, MH files the deceptive notice of entry.
A rapid response.
A rapid defensive move. Designed, it appears, to get that procedural denial slammed down before any judge's eyes could land on page 115, naming Mueller, or page 117 listing Denning. Maximum denial speed.
And this ties back to MH's actions earlier in the state court, right? Where she seemed focused on discrediting the plaintiff's claims about this network.
It connects perfectly. Remember the September 8th hearing? Morgan Hibner brought in exhibits. The plaintiff has this huge online journal, like over 4,000 entries.
Right.
But MH cherry-picked just 12 specific posts. And guess which posts they were?
Let me guess. The ones mentioning these exact same names.
Bingo. The specific posts that named or referenced people like Mueller, Denning, the law firm, the very people she later allegedly tried to shield with the procedural fraud.
So the argument is the state court case itself wasn't really about the surface issues, like custody. It was engineered to create an official record labeling the plaintiff as, delusional or paranoid for even talking about these powerful figures.
That's the inference drawn by the sources, yes. That the state case was subverted, turned into a lawfare tool specifically to discredit the plaintiff and protect those names he was exposing.
And the procedural fraud on October 10th was the final step, the kill switch.
It looks like the necessary closure mechanism. They stopped the list of names from getting official appellate review, minimizing that risk of a judge making an FBI referral. They buried it procedurally.
The coordination seems almost military, especially when you factor in the immediate appearance of a replacement lawyer.
Absolutely. It wasn't just MH filing the dodgy document on October 10th. On that exact same day, this new attorney, Troy G. Pickett, filed his notice of appearance in the appellate case.
Same day. That can't be a coincidence.
Highly unlikely, according to the analysis. It points to a very coordinated effort. Step 1, bury the damaging document with procedural fraud. Step 2, simultaneously insert the next network asset, Pickett, to ensure a smooth transition and keep the lawfare machine running.
Okay, so MH gets the appellate case dismissed procedurally. Mission accomplished, you might think. But she didn't exactly stick around to enjoy the fruits of that alleged victory, did she?
No, she didn't. Just 11 days later, October 21st, 2025, she filed something called an agreed motion for withdrawal of counsel.
Agreed. And this brings us to the second instance of alleged procedural fraud based on a misleading title.
That's right. She titled the motion Agreed, but the sources are quite clear. The plaintiff was never consulted. He explicitly stated he did not agree. And maybe the most telling part.
What's that?
The signature block on the motion, the spot reserved for the plaintiff's signature to show his agreement. Conspicuously blank.
So she filed something claiming agreement when the document itself showed there was no agreement. That seems blatant.
The plaintiff's objection calls it a material and sanctionable misrepresentation. Pretty strong language.
So why try this rushed, apparently fraudulent exit? What was the motive?
The primary motive alleged in the plaintiff's objection to, quote, flee the jurisdiction of the state court.
Flee? Why?
Because at that exact moment, MH was facing serious heat. There were at least 4 pending motions for sanctions against her, all filed by the plaintiff, alleging professional misconduct throughout the case.
So if she withdraws successfully,
she tries to escape the court's power to rule on those sanctions, to hold her accountable for her alleged misconduct. It's an attempt to evade judgment.
Fleeing jurisdiction to avoid sanctions. That's a serious allegation. And the timing again seems suspicious, more than just convenient.
It looks very much like potential retaliation, according to the sources. That withdrawal motion, filed less than 24 hours after the plaintiff escalated things significantly.
How so?
By filing a motion for preliminary injunction against Morgan Hibner personally, naming her individually in the brand new federal civil rights lawsuit. Case number 4.25 CV 04890.
So she gets sued personally in federal court, and the very next day tries to bail out of the state case.
The timing strongly suggests bad faith, yes. A potential retaliatory move to try and minimize her exposure in the state case she was clearly trying to abandon quickly.
And beyond the bad faith, the motion itself was problematic procedurally, wasn't it? Even ignoring the agreed title issue.
Yes, it violated a specific rule, Texas Rule of Civil Procedure 18A.
Which says what?
It mandates an automatic stay of all proceedings in the case, and that stay had already been triggered.
Plan.
5 days earlier, on October 16th, when the plaintiff filed that second verified motion to recuse the judge.
Okay, automatic stay means everything just stops.
Okay.
No substantive motions, no orders, nothing.
Exactly. The court hits pause until the recusal motion is decided. So filing a substantive motion, like an agreed motion for withdrawal during that mandatory stay period, that's a direct violation of the rules.
So the plaintiff argued this showed.
His objection argued it demonstrated MH's, quote, contempt for the rules of procedure and the law. That she was so desperate to get out, she'd violate an active court order halting all proceedings, smashing the emergency glass on her way out, essentially.
It definitely paints a picture of extreme urgency, maybe even panic, to exit that jurisdiction and avoid accountability. And who's waiting in the wings to take over this mess?
The new face? Troy G. Pickett.
Okay, let's profile this new player, Troy G. Pickett, or TGP. He filed his appearance on October 10th, same day as the initial alleged fraud, and he's the guy listed as incoming counsel in MH's withdrawal attempt. Why is he significant?
Well, the legal vaccine pipeline immediately flagged him, using patterns associated with known network tradecraft.
And the main tactic flagged was something called address obfuscation. Can you explain that for us? Well, what is it and why is it a red flag?
Sure. Address obfuscation is kind of a standard defensive tactic used by sophisticated actors who want to avoid automated data analysis, basically.
How does it work?
When a new attorney, like TGP here, files their notice of appearance, they have to provide an address. The goal of obfuscation is to give an initial address that scores really low on our proprietary geoindex, meaning an address that looks nondescript. Maybe it's a shared office space, a virtual office, a low-traffic location, something designed to look completely unremarkable so it slips past the first wave of data analysis that's looking for high-value, known network locations.
Okay, so TGP started with one of these low-score, seemingly unimportant addresses.
Yes. But the pipeline analysis doesn't just stop at the first address given. By cross-referencing metadata, other filings, known network links, things like that,
You found another address.
it quickly pierced the obfuscation, yes, and identified a secondary high-value address linked to him. The Hunt Law Firm at 23212 Red River Drive in Katy, Texas.
And this address, how does it score on your geoindex? Why is that significant?
This second address scores over 90,000 points.
90,000. How does that compare?
Well, look, a typical small or medium law firm address might score, I don't know, a few hundred points, maybe a few thousand. A score of 90,000. That indicates a highly strategic, high-value node within the network structure we're tracking.
Wow.
And the sources even point out something more specific. That 90,000 plus score is higher than the known residential address score for Philip E. Denning.
Denning. One of the high-profile names MH allegedly tried to protect with the first procedural fraud.
The very same. That comparison is key. It immediately suggests TGP isn't just some random lawyer stepping in. He's potentially coming from or connected to a very strategic, possibly high-ranking position within this alleged network's infrastructure.
And you mentioned this tactics starting low score, then revealing a high-score connection is a known pattern.
Yes, it's identical to the pattern we saw when Morgan Hibner herself first appeared in this case. She initially filed under a low-score address before her deep connection to the very high-score Adams Law Firm was established.
So, the consistent use of the same tradecraft.
It strongly suggests, according to the analysis, that TGP is operating from the same playbook. It reinforces the idea of a coordinated network operation.
Okay, beyond the address, TGP's profile also connects him to another lawyer the plaintiff encountered previously, A. Wayne Bailey.
Correct. The data pipeline found what it calls a significant co-clustering of data points between TGP and this A. Wayne Bailey.
Co-clustering means?
It means their data overlaps in meaningful ways. They share educational history, yet both went to South Texas College of Law, but the algorithm sees more than just being alumni. It suggests closer operational or professional ties based on multiple data factors.
And why is A. Wayne Bailey himself a figure of interest here? What's his story?
Bailey is flagged for a couple of major reasons. First, he's another attorney the plaintiff actually consulted with back in 2023.
Which is problematic because
it fits a pattern. The network seems to consistently insert or utilize lawyers who've had prior, potentially confidential contact with the plaintiff. It raises questions about information leakage or strategic placement.
Okay. And the second reason Bailey is flagged?
He himself exhibited some major anomalies, according to the pipeline. Specifically, when he met with the plaintiff, he presented himself as a former judge.
But the sources suggest that might not be accurate.
That's the anomaly, yes. The pipeline data indicates he might actually be an active judge, not former.
An active judge consulting with a potential litigant while possibly tied to this network.
If true, yes. It raises profound concerns. An active judge consulting with the plaintiff, possibly while maintaining ties to this operational network, and now being algorithmically linked to the incoming network counsel, TGP. It paints a disturbing picture about the potential reach and integrity issues within the legal system here.
So that's like an interconnected web. MH uses obfuscation, hands off to TGP, who uses the same obfuscation and comes from a high-value network location.
And TGP, in turn, is linked to Bailey, who potentially exploited prior client contact and whose judicial status itself is a major red flag.
It doesn't sound like a series of random lawyers. It sounds like an organized legal machine.
That's the pattern the sources identify. MH's exit isn't random. It's apparently being managed by someone, TGP, who operates using known network protocols. And his background connects directly back to other compromised or anomalous legal figures like Bailey, who've previously intersected with the plaintiff's attempts to get legal help. It looks like a closed-loop system designed to control the narrative and, ultimately, the flow of justice.
Okay, so the network makes these aggressive, allegedly fraudulent moves.
Yeah.
The plaintiff obviously had to respond. How did they counter MH's attempt to withdraw and dodge those sanctions?
The response was swift and pretty direct. The plaintiff filed an emergency objection to fraudulent agreed motion for withdrawal, motion to strike, and renewed motion for sanctions.
Quite a title. What was the core demand?
Simple, really. Deny MH's withdrawal request until the court rules on all 4 of those pending sanctions motions against her. Don't let her abandon ship and leave her alleged misconduct unaddressed and unsanctioned. Force accountability first.
Makes sense. But beyond just blocking her exit, the plaintiff had already put another move in play in the state court, right? Something designed to neutralize MH's earlier win.
Yes, that second motion to recuse filed back on October 16th. The sources refer to this as the checkmate move.
Checkmate how?
It was a deliberate strategy. It basically weaponized the very delays the network itself often relies on. Remember, the first motion to recuse the judge took 21 days to resolve.
Yep.
This second motion was much more complex. It involved these serious allegations of fraud against 2 different courts. So the reasonable expectation was it would take even longer to resolve, maybe 3, maybe 4 weeks.
And why was that expected delay the key countermeasure? What did it achieve?
It all comes down to the timeline of the temporary orders themselves. Those orders MH fought so hard to get finalized and put on the docket. They were set to expire naturally anyway around November 10th. That's 60 days after they were first verbally issued.
I see. So if the second recusal motion tied up the court for 3 or 4 weeks.
As anticipated, yes. Then the temporary orders would simply expire. They'd run out of time before they could ever be formally signed, finalized by the judge, or made appealable.
So MH's entire complex maneuver to get those orders seemingly entered on the docket back on October 10th, it gets completely nullified just by the clock running out because of the plaintiff's countermove.
Exactly. The network's short-term procedural win evaporates into a long-term loss in the state court context. It dismantles their effort to create that permanent, discrediting state court record based on those temporary orders.
But all this chaos in the state courts, while maybe frustrating for the plaintiff day-to-day, it actually served a larger strategic purpose for him, didn't it? It unlocked something else.
It did. It fulfilled what the sources call the federal gambit.
Meaning the breakdown in the state court, the failure to get proper process or redress because of all this alleged procedural abuse, it opened the door to federal court.
Precisely. It created the necessary predicate to argue that the state system was failing to protect his constitutional rights, justifying federal intervention. Which brings us to that new federal civil rights lawsuit we mentioned earlier, case num 4.25 CV048990.
Okay, let's unpack that federal suit. Who are the defendants now? It sounds like it goes beyond just the lawyers.
Oh, yeah, it's much broader. The federal suit names Morgan Taylor Rivera Hibner individually, her firm Adams Law Firm, but also Fort Bend County itself, Sheriff Eric Fagan in his official capacity, and several named and unnamed sheriff's deputies, specifically mentioning Bell, Gloria, and Walker.
Wow, so it directly connects the private lawyers to the state actors, the county, the sheriff's office.
That's the core claim. A conspiracy.
And the central legal claim is under 42 U.S.C. Section 1983, conspiracy to violate civil rights. For listeners, what does Section 1983 actually do?
Section 1983 is basically the main tool citizens have to sue state and local government officials or entities in federal court when they violate someone's constitutional rights while acting under color of law, meaning using their official authority.
So the lawsuit alleges that private actors, like MH and her firm, teamed up with state actors, the deputies, maybe the county system itself, to strip the plaintiff of his rights.
That's the allegation. A coordinated conspiracy specifically through things like fabricating judicial orders, like that Index 81 filing, and weaponizing law enforcement against him.
Can you give examples from the sources about how law enforcement was allegedly weaponized? What specific actions are cited?
The complaint apparently details several instances. For example, it alleges Deputy Bell was coordinating with the adverse party hours before a missing child report was even officially filed, actively helping conceal the child, sharing confidential info, things like that. Separately, Deputy Walker is accused of obstruction of justice, specifically refusing to file a police report when MH's process server allegedly trespassed on the plaintiff's property. Essentially using his badge, the allegation goes, to shield the actions of the private party's agent.
And the lawsuit doesn't just target the individual deputies, right? It goes after the whole county and the sheriff.
Right.
That requires a specific kind of legal argument, doesn't it?
It does, a very high bar. It requires what's known as a Monell claim. This is absolutely critical.
A Monell claim. Explain that.
To successfully sue a municipality like Fort Bend County or a leader like Sheriff Fagan in his official capacity, under Section 1983, you can't just say, one of your employees messed up. You have to prove the constitutional violation wasn't just an isolated incident by a rogue employee.
You have to prove it was caused by
an official policy or, more often, a persistent widespread custom or practice within that municipality or department. Even if that custom isn't written down, if it's so common, it basically functions as policy.
So the plaintiff is arguing that MH's alleged conspiracy with deputies was only possible because the sheriff's office itself had a systemic failure. A custom.
Exactly. The lawsuit explicitly alleges municipal liability under Monell. It argues MH's actions were enabled and successful because there was a persistent, widespread custom within the Fort Bend County Sheriff's Office.
A custom of what?
A custom of failing to properly investigate the plaintiff's numerous prior reports and complaints, while conversely actively assisting the adverse parties involved in the dispute and allowing the Sheriff's Office's own procedures and authority to be weaponized against him.
That's a huge claim. Proving a Monell claim is notoriously difficult.
It is. You need to show a pattern, demonstrate that the institution itself, not just individuals, fostered or was deliberately indifferent to these violations. But the plaintiff seems to be using all the documented evidence from the state court, battles the alleged fraudulent filings, the specific coordinated actions of deputies like Bell and Walker as the foundation to meet that high Monell standard.
So every procedural trick MH allegedly pulled in state court to hide information
now becomes Exhibit A, B, and C in a federal civil rights case aiming to prove systemic corruption and failure at the county level. It's designed to connect the private lawyers, their firms, individual deputies, and the county leadership all together.
It's a complete inversion. The tactics supposedly meant for concealment are now the very evidence being used for maximum exposure.
That's the essence of the federal gambit strategy as described, systematically linking all the dots the network allegedly tried so hard to keep separate.
Okay, so this deep dive has really laid out the anatomy of this alleged lawfare. It's quite a sequence.
It really is. We saw the precision, that alleged deceptive document title tactic used to engineer a procedural dismissal, get the case thrown out as moot to bury those sensitive names.
Then we saw what looked like panic. That immediate, allegedly fraudulent, agreed withdrawal motion MH filed, apparently trying to dodge 4 pending sanctions motions.
Right. followed instantly by the deployment of the new counsel, Troy G. Pickett, who comes in already using known network tradecraft like address obfuscation linked to a high-value network location.
What really stands out is the strategic use of time on both sides.
Yeah, the network relied on speed, right? Get that dismissal fast before anyone reads the petition. But the plaintiff countered with delay, using that second recusal motion as a checkmate move to let the temporary orders just expire on their own.
And the ultimate consequence of the state court's failure to stop all this alleged procedural fraud
Is this massive federal lawsuit, a suit that isn't just targeting individuals but is alleging systemic, customary failures within an entire county apparatus, potentially implicating leadership. It promises to shine a very bright, uncomfortable light.
And those names MH supposedly tried so hard to shield back in October, Mueller, Denning, the law firms, they're not buried anymore.
Not at all. They're now central allegations in a federal civil rights complaint. The whole defensive strategy of procedural concealment seems to have spectacularly backfired, exposing the very obstruction it was designed to create.
Which leaves us with a final kind of provocative thought for you, the listener, to mull over.
Yeah, consider this. The network's original plan, it seems, was built on one core assumption that no judge would ever actually read the sensitive details in that first petition for a writ of mandamus. Keep it buried.
But now
Those details aren't just exposed, they form the very legal foundation for a Monell claim against a county and its sheriff in federal court. So who's really in the hotter seat now?
is the lawyer, Morgan Hibner, who's allegedly trying to flee state jurisdiction to avoid sanctions?
Or is it the new lawyer, Troy G. Pickett, who just stepped right into the middle of a federal conspiracy lawsuit where every single move he makes will now be intensely scrutinized through the lens of this established network tradecraft and the allegations against his predecessor and alleged associates? Who's more vulnerable?
Definitely food for thought. Thank you for joining us for this deep dive. We'll see you next time.